Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can ring on the landline number which appears at the bottom of the screen, and as always, a very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So any messages that you send on that mobile number will be sent through to me here live in the studio, and I'll be able to answer your questions live on air. Now, on this show, we get numerous questions. Occasionally, you get matters which are quite complex. Occasionally, I need to look at documents before I can advise in detail. Now, if that's the case, that your matter is complex or I need to look at documents, that's not a problem. You can still send your question in and I will then arrange to speak to you off air and have a more thorough discussion with you off air. And this is a service that we provide completely free of charge. So whether you speak to me live here in the studio, whether you send your text messages in and I answer those questions, or we need to have a more thorough discussion off air, it's a service that we provide completely free of charge. So please do continue to send your questions in. Now, on the show, as I said earlier, whether it's an immigration law matter or any other matter relating to English law, it could be a criminal law matter, family law matters, whatever it is, do send your questions in. So let's look at some of the questions that have been coming in today. And the first question that's come in is from Brother Sajjad. And his question, I was looking at this just before we came on air, relates to a further leave to remain application. So he is applying for an extension of his visa. And he says as follows. My wife is in receipt of PIP, and I am working as well. However, in January, my job is likely to come to an end. I need to apply for an extension in May. Do I need to be in employment when I apply for that extension? Now, common question that comes up in practice. This is an extension application that Sajjad needs to put in May. His concern is he's working at the moment, his job's going to come to an end. What's going to happen? Look, in terms of the income that you need in order to extend your visa, we'd need a lot more information. So we'd need to look at how much PIP you're getting. We'd need to look at whether you've got children or not. We'd need to look at whether you're having to pay rent and council tax. So we need to look at and assess your expenditure according to the government formula, Home Office formula, and then work out how much income you would need. However, what I would say to you is this, that if you are, if your wife is in receipt of PIP, then there is more flexibility. You don't need to be earning £29,000 a year, so it helps. You can take whatever the requirement is based on whether you've got children, based on whether you pay rent, whether you pay council tax, whatever that financial requirement is, you can meet that with PIP and it could be employment income. Now, the problem is I can't advise you at this stage in terms of the level of employment income that you would need. What I can say to you is, look, it doesn't matter if your job is coming to an end in January. Let's say you're short by £700-800 a month. You've got PIP coming in, you've got universal credit coming in, and let's say you're short, according to the government formula, by £700-800. Now, if you start a job even a month before your visa is going to expire, you can take that income into account. So you don't need to be working for 6 months in that job. You don't need 6 months of continuous pay slips. Even if you're in that employment for a short period of time, that will still be okay. And the reason for that is because your partner is in receipt of PIP. That makes things much easier. So your matter, Sajjad, is quite complex. What I would suggest to you is that what you should do is seek advice from an immigration lawyer. They'd need to look at your income, they'd need to look at the level of PIP, then look at your expenditure according to the government formula, and then tell you exactly how much money you need coming in. So that's basically the position in terms of what you need to do. Now, next question that we've got coming in is from Luqman, and Luqman is inquiring about his mother, and he says, my mother has indefinite leave to remain in her passport. There is a sticker in her passport. She wants to register for an e-visa. How does she do that? And does it cost anything? Right, okay. Now, so what Luqman is saying is that mother wants to apply for an e-visa. How do we go about that? Now, e-visa is something that's going to be coming in from the 1st of January 2025. So if you've got a BRP card, you do need to register for an e-visa. The difficulty we've got at the moment is that there are still some people who don't have a biometric residence permit. What they've still got is their indefinite leave to remain in their passport. So it's a sticker in their passport. And I've even seen some people who were granted indefinite leave a long, long time ago, maybe 15, 20 years ago, when the Home Office didn't really apply a sticker to the passport. They used to just stamp the passport and it would say indefinite leave to remain. So there are still people with settlement, indefinite leave to remain, but they don't have the BRP card. The problem is this, that if you want to apply for an e-visa, you do need that BRP card as a starting point. If you don't have a BRP card and you're in the category that we've talked about, where somebody has indefinite leave to remain in their passport by way of a sticker or a stamp, then you would need to first of all apply for a BRP card. So Luqman, the first step for your mother is for her to apply for a BRP card. Now, in terms of applying for that, you've asked about cost. There is no Home Office fee for a BRP card where somebody has the indefinite in a passport and they're applying for their first BRP card. The fee for that has been waived. Used to be a couple £100, but a couple of years ago, the Home Office stopped charging for that particular service, the first BRP card that you apply for. Now, once your mother has the BRP card, she will then be able to apply for or register for the e-visa. And again, that is relatively straightforward. There is no fee payable for that. In most cases, what I do find is people are able to do that themselves, which is fantastic. Occasionally, people struggle, and then what I would suggest is, if you are struggling, then to seek the advice of an immigration lawyer. But that's basically where we are. Now, let's look at some of the other questions which have been coming in. The next question is from Zia, and he says as follows: good evening. My son came in 2004 when he was 5 months old. Now he is 19 years old and he is on the 10-year family route and has recently got his third extension. Can he apply for indefinite leave to remain? So son came to the UK in 2004 when he was 5 years old. He is now 19 years old. He's on the 10-year family route. Can he apply for indefinite leave to remain? Now, it's on his third extension. Now, you do need to look at the letter he received when he was granted his last visa. I suspect he hasn't been placed on the 5-year route to settlement. The way the Home Office deals with children or those who are under the age of 25 and those, the way that they deal with adults is different. You get a different grant letter. So if he's been placed on the 5-year route to settlement and he's then completed 5 years, then he can apply for indefinite leave to remain. What you need to do is look at the last letter that he received when the last visa was granted to him. Was it granted under the 5-year route or not? If it was, then potentially he could apply for indefinite leave to remain once he's completed 5 years. Right, let's look at the next question that's come in. Next question is from Brother Ahmad. I have moved from my old address that I put in the nationality form. How will I know the result of the application? Well, Brother Ahmad, in terms of the outcome of the application, the Home Office does not write to you at your home address. They will email you. So you need to look at your emails. You need to check your emails. That's where you will receive notification as to what the outcome of your application is. Now, the next question you ask is, do you need to apply for an e-visa? Because you've applied for nationality, you're about to get your nationality, then you don't. But let's say there's a delay in you obtaining your nationality and you want to travel in January, February next month, you still haven't got your nationality, then you will need to register your BRP for an e-visa. So if you're traveling January, February, and you haven't got your nationality, then you will need to register for the e-visa, which will allow you to travel. Your employer may need it. Now, just because you've got your nationality application, that doesn't stop you from applying. Now, if you're not traveling anywhere, you don't need to prove your status to anybody, then you don't need to wait. You don't need to do anything. You can simply wait for the outcome of your nationality.
Sainsbury's? Oh, he made her money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses, like measles and whooping cough, is rising.
If we're not vaccinated,
We're not protected.
and could get seriously ill. Risking lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Oh, he made her money.
Hey Sainsbury's, explain it, will you?
well. The same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum. Welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a popular way of getting in touch is to send a message on the mobile number which is also at the bottom of the screen. Or if you're watching live, you can leave a message in the comment section. And again, that will be fed through to me here live in the studio. let's look at the next question that's come in. It's quite a long question from Brother Usman. Thank you very much indeed for sending that question in. Let me read the question out and then we'll look at what the best way forward is. It is quite a long question, so please do bear with me. Now, what Brother Usman says is as follows. I have to apply for my spouse's visa extension. I am the husband, employed. My work income is £24,744, whereas the requirement is £24,800 with 2 children. Okay, so this must be under the old rules. So it's the wife and the 2 children applying. So what Brother Usman is saying is that his income is 24,744. So he's a little short of the 24,800 income requirement. He says it's just £56 short. Husband was self-employed as well during March and April, and he earned £1,400. He says, so my question is, can we show self-employment income as well as the employment income I've referred to above? If yes, do we need to show and submit for 1 year or 2 years the self-employment tax documents? And is there a need for a chartered accountant stamp or just the normal accountant stamp? Okay, now, very good questions, Brother Usman, and I will deal with each point that you've raised. Now, the first issue that you raise is this, that your income isn't sufficient at the moment. Can you combine your employment income over the last 6 months with your self-employment income? Look, the starting point is this. You can combine employment income and self-employment income. However, the problem is it has to be, once you're self-employed, your income has to be shown over the period April to April. So the tax year April to April. So what you can't do is look at your last 6 months income now. If you're having to apply now, you're going to have to show the income from April 23 to April 24. So look at the period first. The period that you would have to rely on if you're relying on self-employment income is April 23 to April 24. In that financial year, you look at your self-employment income, and you've already said that you think you've earned about £1,400. Fine. Then, for the same period, not any other period, for that same period, you need to look at your employment income. So what have you earned in that period? So combined April to April with your self-employment income and your employment income in that period, do you reach the required amount of 24,800? So that's the starting point. And if you do, you just have to show some evidence that you are still in self-employment and you are still in employment. It doesn't matter how much you're earning, as long as you're in self-employment and you're in employment, the same that you've relied upon at the initial stage when you applied for during April 23 to April 24. So if in that period you've earned the right amount of money, that's fine, you'll meet the requirement. Now, we don't know how long you've been in this particular employment or how much you were earning in that period. So let's say, for example, if we go back to April 23 to April 24, your income was much lower. So let's say you were only earning £20,000 a year. Then you wouldn't meet the requirement because £20,000 April 23 to April 24 plus your £1,400 isn't going to be enough. So you need to get your income right in that period. Assuming it's okay, you just need to show the documentation for that particular period, April 23 to April 24. You don't need to go back 2 years. So you don't need to show the profits for April 22 to April 23 and then 23 to 24. You can just rely on your latest year's income, latest financial year's income. Now, the third question that you raise is whether the documents that you submit, whether they have to be stamped by a chartered accountant or not. Well, the requirement is actually this, that you are required to submit your financial accounts. So you have to submit your profit and loss account and your balance sheet, your financial accounts, financial statements. Now, that has to be produced by a qualified accountant. Now, there's a list of different types of accountants whose documentation will be accepted. And it's off the top of my head, a chartered accountant, a chartered certified accountant, and an accountant who is IFA registered. So it has to be an accountant who is registered with a body which the Home Office will accept. So there's about 4 or 5 different types of accountants whose documentation will be acceptable. Now, what happens, what the situation is with the accountancy profession is that accountants don't have to be regulated unless they're doing audit work, so unless they're working with quite large employers whose accounts need auditing. Smaller businesses, medium-type businesses, an accountant can do the accounts even though they may not be chartered accountants, chartered certified accountants, etc. Now, the problem with using an accountant who's not registered with one of those bodies is that the Home Office will not accept the financial statements, the accounts produced by an accountant who's not registered. So it has to be a registered accountant. And if you do go down the route of having to rely upon your self-employment income and your employment income, then you need to bear in mind that in terms of your self-employment income, the documentation that you will need to submit is your financial accounts prepared by a recognized accountant, your tax return, your SA 302, then a tax overview, and your bank statements from April 23 to April 24, and your latest bank statement. So that's going to prove your self-employment income. And if you're obviously combining your self-employment income with your employment income, then as far as the employment income is concerned, you will have to show your pay slips for the period April 23 to April 24, your bank statements where your salary has gone in for the same period, April 23 to April 24, a letter from your employer confirming your employment, and also your latest pay slip, your latest bank statement, which confirms that you are still employed. Because if you think about it, although the Home Office is assessing your income during the period April 23 to April 24, they still want to know whether you are still in that self-employment, whether you are still in that employment now. Because that was in April. So your documentation, which will prove your income, is up to the end of the financial year in April. So many months have passed since then. May, June, July, August, September, October. We're 6 months down the line. So they want to know at this stage, not the amount you're receiving, but at this stage, some proof that you are still self-employed and employed. And normally that proof is by way of your bank statements. Your bank statements and your wage slips will show that you're employed. Your bank statements will show your salaries going into your bank account. And in terms of your continuing self-employment, your bank statements should show some level of income from your self-employment. Now, Brother Usman, I've tried to go into this in as much detail as possible based on the information that you've provided. If you're unsure of any aspect of that answer, please do get in touch. You sent a message in. You can send your message, a follow-up question in, and I will try and deal with that as well, inshallah, as soon as possible, as soon as it comes in. But thank you very much indeed. Now, let's look at the next question that's come in. And it's a question from Farhan. And what Farhan is saying is that he's applying for a spouse visa to join his wife in the United Kingdom. And in relation to that, what evidence does he need in relation to the accommodation that he will be living in? So Farhan's applying for a spouse visa to join his wife in the UK. What's the evidence for the accommodation that he will be living in the United? Now, there's a couple of different pieces of evidence that you would need to put in. Normally, it's proof of ownership of the property. So if your sponsor owns the property, they will normally include evidence of that. So it will be the deeds for the property. If they are renting, they will include a copy of the tenancy agreement. If they are living with family, then they would get a letter from the family member that they're living with, confirming that they can stay at the property. So it depends on the basis upon which your sponsor, your wife, is living at the property where you will be joining her. If she owns the property, submit a copy of the deeds. If she is renting, submit a copy of the tenancy agreement. If it's family, a letter from the owner and a housing report confirming this.
Sainsbury's? Oh, he made her money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses,
Like measles and whooping cough, is rising. If we're not vaccinated,
we're not protected.
and could get seriously ill, risking lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Oh, he made her money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum, welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, a popular way to get in touch is to send us a message on the mobile number which also appears at the bottom of the screen. I think we dealt with a question just a few minutes ago and the callers called back asking for further clarification. let me repeat the question that was posed, and let's break it down in a bit more detail. So the question that's been posed is, we as a couple came to England in 2004 with our son. So came as students with our son in 2004. Son was only 5 months old. We overstayed. In 2018, we were granted a visa on the 10-year route. So 2018, we were granted a visa on the 10-year route. Okay. Last month, we got our third extension. Okay, so they've done their 5 years. Now they're on their third extension. They've done the first and second, they're on their third extension. Okay. Can my 19-year-old apply for indefinite leave to remain? Okay, look, the rules for that is as follows. There are certain conditions which need to be satisfied for that. Your child needs to have arrived in the UK when he was a child. Yes, you satisfy that requirement. You must have lived in the UK for 5 years on a relevant visa. So yes, he's got a visa on the visa that you got from 2018 onwards. So he's had the visa for 5 years. Yes, came as a child, has had a visa for 5 years. But that's not enough. It's not simply that the child has lived in the UK for 5 years with a visa. The requirement that I was asking you about is you have to look at his the letter granting him the visa, the last one, and that visa has to be on the basis of his private life. So it's got to say that his visa, the 19-year-old's visa, is being granted on the basis of his private life. You have to look at the wording. So he came as a child, yes. He's been on a relevant visa for 5 years, yes, since 2018. The third thing is you need to look at his letter. It needs to say he's being given a visa based on his private life. Now, that is normally given to somebody who's aged between 18 and 25. Now, if he has that letter that he's got a visa based on his private life, then he can apply for ILR because he came as a child, he's completed his 5 years, and he's got the current visa on the basis of his private life. So they're the requirements that need to be fulfilled. Now, if you look at his, not yours, his visa grant letter, and it does say that it's on the basis of private life, then what I would suggest is that there is a possibility he is going to qualify for indefinite leave to remain now. So that being the case, speak to an experienced immigration lawyer. This is quite a technical rule which most people haven't really come across. So came as a child, legally on a relevant visa for 5 years, yes, and he's been granted a visa on the basis of his private life. That's what you need to look for. It's the basis of the grant. If it says, yes, you're being granted a visa based on your private life for the child, forget the parents, for the children, then speak to an immigration lawyer. There's a possibility he does qualify for indefinite leave to remain. So, without looking at the documents, I've tried to advise you as thoroughly, precisely as I can. Now, if you want me to look at this further, it's not a problem. If you are able to send on that mobile number the visa letter for your son, then I can check to make sure he's in the correct visa category to be able to qualify for indefinite leave to remain. But thank you very much indeed for that question. Right, let's look at some of the other questions that have been coming in. And this is a question from Junaid. And this is something that comes up quite regularly. And what Brother Junaid is saying is that, and it's in respect of his wife, my wife has been in the UK now for 5 years. She came in October 2019. Actually, we're in October 2024, so it's been 5 years. However, her BRP card, so her visa card, does not expire, or her visa, I should say, does not expire until next year. Can she apply for indefinite leave to remain now? So this is actually something that comes up in practice quite regularly, where somebody who's here on a spouse visa, on a partner visa, they've completed their 5 years in the United Kingdom, but their last grant of visa is such that it's not coming to an end now. It's going to continue for a few more months. Do they have to? The question is this, isn't it? Can they apply now for indefinite leave to remain, or do they need to wait until the completion of their current visa? The answer is actually quite simple. Once they've completed 5 years as a partner in the UK, then they are able to apply for indefinite leave to remain. In fact, they can apply 28 days before the 5 years are completed in the United Kingdom. So, in short, your wife, Junaid, does not have to wait until this current visa comes to an end. She can if she wants. Now, there may be circumstances in which you say, you know what, she's completed 5 years, but we don't want to apply for indefinite leave to remain now. In practice, what seems to happen is somebody's unable to pass the English test, the Life in the UK test, they need more time. So even though they've completed 5 years, they don't apply for indefinite leave to remain because there's something that still needs doing. Or it could be that somebody started work late and they haven't got their 6 months pay slips that they need to submit in order to apply for indefinite leave. They still need to do a couple more months. So they decide that it's not time to apply for indefinite leave to remain at the moment. So in that situation, you don't apply for indefinite leave to remain. You choose to wait. But thank you very much indeed for that question. The next question that's come in is from Uzma. And Uzma's question is in relation to her child's nationality. And what Uzma says is that my daughter was born in the United Kingdom, has lived in the United Kingdom for the last 10 years. And she has just turned 10, I should say. Can she apply for nationality? What kind of proof will the Home Office want? Okay. Now, that is an interesting question. Something, again, that comes up in practice. Child born in the United Kingdom has reached the age of 10, has lived in the United Kingdom for the last 10 years. Now, they can apply for British nationality. The application is submitted on Form T, so they can apply for British nationality. What documentation do they need? In terms of documentation, it's not too extensive. A few simple documents that hopefully you should be able to get. Birth certificate should be readily available through proof that the child was born in the United Kingdom. The other documents that they're asking for is really proof that the child has lived in the United Kingdom. So it would be normally 3 types of documents I tend to put in. 2 you really do need to get. 1, it's fine if you don't have it. the Red Book, which is given to children, or the parents, I should say, when a child is born, has a record of their vaccinations, etc. So Red Book, a copy of the Red Book, that sort of proves the child was in the UK in the first couple of years. I don't think it's that important. What you should get is the following two documents to prove the child's residence in the UK. Number one, child's medical records. So not a letter from the doctor, but the medical records. And that will have, from when the child was born, an entry in the records of each time the child's visited the doctor, each time something's happened. So that produces evidence of the child being in the UK over the last 10 years, whether it's vaccinations, whether the child's ill. Every time you've gone in, obviously a computerized record is kept, and that record, the medical records, is what the Home Office wants to see. The second document, which you must get, is that obviously the child, when the child turns 4 or 5, child will be starting nursery or school, you need to get hold of the letter from the school that the child has attended and is attending now, confirming the period of attendance. So it could be that the child's 10, 11 years old, so they might have been to infant school. So you get a letter from the school saying child attended school from this date to this date. It might be that they've now moved on to junior middle school. You get a letter from that school as well, confirming that they've attended, they're attending this particular school as well. So what the Home Office is trying to see is that the child was born in the UK and then has lived in the UK for the last 10 years. That takes us to our next break. Inshallah, we should be back in the next couple of minutes. See you then, inshallah. Assalamu alaikum.
Sainsbury's? Oh, he made her money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses,
like measles and whooping cough, is rising.
if we're not vaccinated, we're not protected and could get seriously ill, risking lifelong disabilities. Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Oh, he made her money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a popular way of getting in touch is to send us a message on the mobile number which is also there at the bottom of the screen. So if you send a message there, inshallah, I'll be able to pick it up and then answer your question. questions live on air. Now, let's look at the next question that's come in. And our next question is, our viewer says, what's the best action to take, type of will and costs included, to protect in case you need healthcare? Types of trust included, who keeps the will safe, etc. Okay, quite a broad question. So just in case you need healthcare. Now, unfortunately, we don't know enough to try and work out what the best solution would be. So I can give some general advice, but we don't know the specifics of this case. So what would normally happen is that, okay, let's take, for example, making the will. You go to a lawyer, you'd make the will. The will obviously deals with your assets after your death. And if you get the will made with a lawyer, the lawyer would keep the will at their office, and you would let your family and friends know that obviously you've made a will and it's with this particular lawyer. So in the event of your death, they will be able to access your will, and then whoever you've nominated in the will will be able to then apply for probate and distribute your estate according to what you've said in the will. So making the will with a proper lawyer, telling family and friends that this is the lawyer who's got my will. That's the starting point. In terms of costs, I can give you a general idea. Most wills for husband and wife are probably in the region of, I would say, between 300 to 500 pounds or thereabouts. Obviously, if your estate, your assets are quite complex, then it could be more. But generally, in a sort of straightforward case where the distribution of your estate is relatively straightforward, you're looking at around 300 to 500 pounds. That's the sort of going rate if you get a lawyer to do it. I think you do get some companies on the internet who advertise to do it quite cheap. If you're doing that, you do need to make sure that you do get somebody who's very experienced in this, and the advice that you get is correct. And that's why I would suggest that you go to a solicitor who's an experienced wills and probate lawyer, who'll be able to guide you properly in terms of options, in terms of how to do it, and there may be tax implications that they will be able to deal with. Now, the next question that's come in is, the next question that arises, I would say, is what happens in the case you need healthcare? So obviously, in terms of the will, that deals with what's going to happen when you pass away and how your estate is going to be distributed. In terms of needing healthcare before you pass away, obviously you've still got your estate at that stage. What I would suggest is, if you've got close family, close friends who can make decisions on your behalf, and if you're concerned about who's going to make decisions on your behalf if you're unwell, what I would suggest is that you look at making a lasting power of attorney. That then gives whoever you nominate the power to make decisions in relation to health and potentially in relation to your estate as well. So that's somebody who can look after your financial interests, your health interests when you are alive, and then the will kicks in and then deals with your estate upon death. Now, the other question that I think might be suggested, and I'm not sure, is that if you've got assets and you're concerned that if you need care, whether the care that's going to be provided to you the cost of that might eat into your assets. How can you protect your assets in that situation? So you don't want the cost of care to be taken out of your assets. How do you protect yourself for that? Now, again, this is something which is quite complex. You, from my understanding, you would be able to now create a trust, maybe put some of your assets into a trust. However, there will be rules about when the care costs are incurred, when it can override any trusts that you've created. There may well be a requirement that a certain period of time must have passed before those assets are protected. Now, that's quite a complex area of law. That's really something that you do need to take advice from a wills and probate lawyer on. So potentially you could look at getting advice on getting a lasting power of attorney. You could then get advice on making a will and get advice on what you could do to protect your assets in case you need care and there's a substantial cost to that care that's provided. So thank you very much indeed for that. Now, let's look at the next question that's come in. Now, I think our brother who sent the question in about the child, they have actually sent the letter in, which is the last grant letter. What would be helpful, to me it looks like, so I did advise previously to our brother that whether the child can apply for indefinite leave to remain will depend on the type of visa the child was granted, and it needs to be on the private life route. The letter that you've sent to me, thank you for sending that, doesn't look like it's on the private life route. Now, what I would ask you to clarify, sorry, we're having to, I'm going to have to ask you more questions, you're going to have to come back to me. To me, it looks like maybe your child wasn't, it just depends on how old the child was. When that visa was granted, was your child 18 years old? Because at the moment, it doesn't look like they've granted the visa on the private life route. It's still under the normal, you're a child on the family route. It doesn't look like it's a private life route grant. So on that basis, child would not be able to qualify for indefinite leave at this stage. It's just the route is different. I'm not sure why it wasn't granted under the private life route. What you could do is two things. Either take it up with the solicitor who dealt with this in terms of whether it's been granted under the correct category or not. Or alternatively, if you do leave your number with the control room, I can have a look at this in a bit more detail to see whether, given that it doesn't look like the grant letter that we would want, whether despite that your son qualifies or not. Looking at the letter, it doesn't look like the visa's on the correct route for him to be able to qualify for indefinite leave to remain. And I think with his age, I would have thought he would have been granted it on the private life route. So two options. You either go back to the lawyer who dealt with the matter and ask him to clarify about this, or if you want me to look at it, it's not a problem. As we say at the outset, I can provide that advice completely free of charge. If you leave your number with the control room, let me have a look at that and I will come back to you on that. It's a slightly unusual route and I have come across it before, but that letter that you've sent through to me just now, it doesn't look like it's on the correct route to qualify, for the child to qualify for permanent stay at this stage. But thank you very much for that. As I said, you can either go back to your lawyer or leave your number with the control room, and I will come back to you as soon as I can. Now, we still have a number of questions coming in. I've possibly got time to look at one further question, and that's a question from Raj, and Raj's question is in relation to indefinite leave to remain. Fairly straightforward question. My wife has completed 10 years in the United Kingdom, wants to apply for permanent stay. Does she need to pass the English tests? Now, I understand why this question is being raised, because there is a slight misconception that once you go onto the 10-year route to settlement, as you go along, every time your visa is extended, you don't need to meet the English language and English knowledge requirement. So there's a misconception that when you get to the end, once you've completed 10 years, you still don't need to meet the English requirement. But that's not the case. When you get to the 10-year mark, when you apply for indefinite leave to remain, at that stage, those two tests, the B1 test in English and the Life in the UK test, both need to be passed and completed. Both have to be passed in order to qualify for indefinite leave to remain. And I know previously, every time you've extended, it's not been necessary. But at the indefinite leave to remain stage, once you've done 10 years, both those tests have to be done unless an exemption applies because of age, illness, etc. But thank you very much indeed for that question. MashaAllah, we've had a number of very interesting questions coming in. Thank you very much for that. Unfortunately, that brings us to the end of the show. Inshallah, we'll be back at the same time next week. Until then, Salam.